Welcome back. We are now going to move to the trial of a contempt case, proving and defending the case at trial. I am still joined by Jerry Height and Carrie Bertrand, who are both lawyers at my office, O'Neill Wysocki Family Lawyers, and also retired Judge Bill Harris out of Tarrant County. Jumping right in here, the trial of a contempt case. We've covered it in some of the others, but if somebody just tunes into this one portion, non-jury versus jury trial. When is a jury trial available? When is a non-jury trial available? Jerry, you want to kick us off on that?
Depends on the relief sought. If they're seeking more than 180 days in jail, or you get a $500 fine. If it gets above that, then you could seek a jury trial. You have a right to a jury trial. Okay. Otherwise, it's going to be heard to the bench. And
the law describes that as the difference between a petty offense and a serious offense, because we're in criminal land, right? So a petty offense would then be anything less than 6 months. We think of that as kind of like a traffic ticket type of thing, whereas serious offense is something that's more than 6 months. Right. We talked a little bit about this in the prior session, but let's kind of cover it again in case somebody's tuning into just this session. Concurrent punishment versus consecutive punishment. Carrie, you want to talk about that one?
Concurrent is going to be preferred unless you want to get into all the complications with consecutive, including the jury trial and I guess making sure your pleadings are in order as well as you've pled properly for either one.
So with consecutive punishment, if it aggregates to more than the 6 months, then it would be in the jury trial territory. Right. Judge, have you ever had a jury trial in a contempt case in your 24 years or so on the bench?
I have not. I brought a jury over once with a pro se that demanded a jury trial, but he did it for a delay. And I had the jury there in 22 minutes. And so he looked at the jury and decided he wanted me to hear the case.
They looked more scary than you did? That's interesting.
I've never tried a jury trial to a contempt case to a jury.
So if your pleadings say 6 months for each count to serve consecutively, but you get in, the petitioner gets in the trial and stands up as the respondent says, well, then I want a jury trial. And the petitioner says, wait, never mind. I don't mean it. I ask for a trial amendment to just say concurrent up to 6 months max. Do you think that's jury trial or non-jury trial?
I think you're right. The jury trial is already triggered. Okay. It's by the pleadings. The pleadings before the court is what you have to look at, I believe.
Okay. All right.
The judge brought up an interesting point, though, when he said he had a pro se, because you have the additional issue of having to give them the right to counsel advice. And I've seen that happen where they get it reset because, I want a lawyer.
So when does the right to counsel invoke?
I think if you're being deprived of liberty, it's invoked.
Yeah.
I think if you got 1 day jeopardy, it's invoked.
And so would you appoint counsel then?
I always did, Michelle, simply because I think technically the judge can have an indigency hearing and find that the respondent indigent or not indigent. To me, it was just always a simpler, easier solution to appoint counsel, and then if the tax costs or something like that as a remedy, just because when you're talking about a criminal case. Appellate courts in Texas have a history of dislike of criminal cases coming out of criminal contempt coming out of civil courts, and historically, some of the decisions they're rather hostile towards the contempt cases. So I think the judge is just looking for trouble if he doesn't appoint a lawyer.
And I would assume as a judge in a contempt case, you want the record to be as clean as possible.
Yes.
Yeah. So what's the burden of proof at trial? Jerry?
It's beyond a reasonable doubt is what it is what it always is. And the burden, of course, is on petitioner.
Jerry, you're so funny. You've been a lawyer a long time.
Too long,
You've
maybe.
forgotten more than you remember, right?
Some days.
So,
yes.
so what does beyond a reasonable doubt mean?
There's a question.
Yeah. Yeah. What does that mean?
We've pondered it for several hundred years.
So in a normal civil case, you've got preponderance of the evidence. And then in some issues in a civil case, it might be clear and convincing evidence. And then in a contempt case, it's more, beyond a reasonable doubt is the criminal standard, right? So in the grand scheme of of the spectrum of burdens of proof, I've always thought of it as preponderance of the evidence is like 50% plus a little, plus a smidge, just barely tipping the scale in favor. And then clear and convincing, I think of more as kind of like that 75%, like more likely than not. Is that
moving the scale?
Yeah.
The way I was taught in law school was preponderance.
That was a long time ago.
A long time ago. we had. I remember reading my stone tablet that I had. Preponderance is is any movement of the scale in your direction.
Okay.
Clear and convincing is a substantial movement where it creates a firm, like the definition says, a firm belief, and then I think that beyond a reasonable doubt you have to push it all the way down.
Yeah. Yeah, I always thought of beyond a reasonable doubt as like 99%. Like,
So I think the term that a lot of the criminal cases use is moral certainty.
Moral certainty.
I believe that's a term I've heard before.
Moral is a great word,
Yeah.
right? Moral certainty. So how in reality, Judge, you're in a trial, you're charged with sitting there listening to the evidence. There's a petitioner who's prosecuting the contempt. There's a respondent. Let's say it's not a clear-cut case that usually happens like on a child support. Let's say it's something that's not so clear-cut. How do you know as a judge when the petitioner's done enough to get to that point?
I think it's almost like the feeling I get from it is it's almost like the Supreme Court justice that says he knows pornography when he sees it. I know reasonable doubt when I see it,
Yeah.
and I can't tell you why. I can't give you any specifics. I think that the judge has to rely on his sense of fairness and adherence to his oath.
Yeah.
So
it's basically a persuasion that you see enough evidence and your scale just goes down to a point where I know what happened. I'm convinced.
Right.
Yeah. What about on the other side of the case, whenever a respondent is defending a case and presenting evidence on affirmative defenses? Obviously, the burden on an affirmative defense is not beyond a reasonable doubt.
No.
So is it preponderance?
I'm not sure the legal standard they apply. It may be clear and convincing.
So how do you know as a judge, as you're sitting there listening to this evidence, and the petitioner's trying to get you all the way to beyond a reasonable doubt, and the respondent is saying, no, I've got these defenses. Like, let's say one of them was failure to comply with a condition precedent or something. How do you know when a respondent has shown enough to prove their affirmative defense?
Again, I think it's that if you create a doubt in my mind as to their involuntary inability is not a good example because that's just all but impossible to prove.
Yeah.
And the appellate cases hold that out. But on a lot of these other defenses, I just think if it creates a doubt in the mind of your trier, then you got there.
So then the affirmative defense, whatever that standard would be creating the reasonable doubt.
I think that's what the whole purpose of the affirmative
Right.
defense.
The opposite of reasonable
is
doubt.
to create the reasonable doubt.
Yeah. Okay.
or to point out the reasonable doubt.
Gotcha. All right, so the respondent, does he have to be there in person? I mean, can a respondent to a contempt case just not show up and hide out, Carrie?
Negative. No, they must be present.
Must be present to win.
Yes, or lose.
Or lose.
Go to jail. You
Or go to jail.
So, all right, so what if you have, Jerry, you're prosecuting a contempt case and you've got a respondent, you've served them with the notice, personally served them, and they don't show up. What do you do? Can you proceed with your contempt case without them there?
No. What you do is you ask the court to issue a capias, arrest them, and force them to appear at the contempt hearing.
So I have a case where the respondent lives in another state and got served, but lives in another state. Will a Texas capias be effective in another state? Judge, you have an opinion on that?
The court's capias says to the sheriff or the officer in the state of Texas. So
That's a problem.
I don't think so. Now, I know that on a lot of like writs and things like that, although it says it's directed to peace officers in the state of Texas, for example, Oklahoma will enforce those, like on habeas corpus and things like that. But on an arrest warrant or a capias warrant, I'm not sure about that.
I've never had one that
I've
an
never-
out-of-state
I've never had it
law
either.
enforcement
Yeah.
would enforce. And from what I understand, the reasoning to be is that when you're in another state, then they have to go through extradition procedures.
Yep.
And that state isn't going to spend their resources extraditing, going through the hearing process of extraditing somebody from one state to come to another state to defend a child support case or a civil type of contempt case. So that's always how it's been explained to me, is that they're just not going to go through all that.
I think it's the same way with a lot of criminal warrants. If you got a misdemeanor warrant out of state, that an out-of-state agency may arrest a person and hold them for a reasonable period of time, but they're going to make you come get them. They're not going to send them back.
Yeah. Right. Yeah. All right. So you can't. So the petitioner cannot proceed against the defendant in absentia. The respondent must be present to win. If they're not present, you ask the judge to issue a capias, which then causes them. A capias is just a civil arrest warrant, basically the name of a civil arrest warrant. And so then the capias is executed to bring that respondent before the court, and they're held in jail, I guess. And let's say they're picked up at 8 o'clock at night, obviously the judge isn't going to show up at the courthouse at 8 o'clock at night, so they're put in jail.
Yeah.
So then what's the process once a respondent is picked up on a capias? What's the process? Let's assume it's a child support contempt for dealing with that capias and the hearing thereafter.
Well, they have to be brought before the court, and I believe on child support they have to be brought before the court within 3 days, and the court either sets a hearing and orders them detained, or they have to be released on bail.
Well, and doesn't the
Postponed.
capias have to have an appearance bond set in it?
Yes.
But I thought if they're in jail waiting for the original hearing, I thought that was, and you're probably right because you're a retired judge, but I thought it was that by the next business day they had to appear before the judge.
So here's what I think it is. I think that the capias has an appearance bond, and they can post the appearance bond.
Right.
If there's not
They
an
can.
appearance bond in the capias, they have to be brought within 24 hours
Right.
for a bond to be set.
If there's no appearance bond,
Right.
but if the capias sets a bond, which Jerry's
Right.
right, it usually does.
Right. It usually does. Should. Ought to. And then I think there's a requirement that the hearing be held kind of post haste, very quickly, if they're in jail,
Yeah.
so that they can have their speedy trial, like you do in a criminal case. All right. So if the respondent has an appearance bond in the capias, let's say it's $1,000, and the respondent gets his mommy to come down there and pay the $1,000 so he can get out of jail and go home. Then what happens if it's a child support contempt? What happens to that appearance bond?
You know what happens.
I know. I'm tossing you a softball, Judge. What happens?
Well, if he's found, even if he's found not guilty of contempt, you can still grant an arrearage judgment, which is a preponderance. You just have to prove that there's wasn't paid. You don't have to prove any contempt stuff. So you're probably that bond is probably going to be forfeited to be applied to the child support.
Yeah. That same rule doesn't necessarily apply to possession contempts or other types of contempts. It would be more like a criminal bond where it could be returned, right?
I think that the court is, if there's evidence offered, the court is required on a finding of contempt. The statute says the court shall award reasonable attorney's fees and costs, and I think that's where that bond might end up on a possession case.
Because it's the bird in hand money.
Yeah.
All right. So, if you're the petitioner in trial in a contempt case, how does the petitioner go about proving their case beyond a reasonable doubt? Like, what are some types of evidence? Carrie, you want to weigh in on this one? Like, what are some evidence? How would you go about trying the trial?
So if it's child support, for example, you're going to want a copy of the Attorney General's register. You're going to want to put the respondent up there probably and ask them questions about, is this the order? Have you been ordered to pay child support? You're going to prove up the actual order language with the respondent, and then obviously enter evidence as to non-payment with the register.
So typical trial procedure, in other words, a contempt trial proceeds just like any other trial, right? So you'd have witnesses,
right.
You'd have exhibits. You mentioned the child support register from the Attorney General's office. How do you get the child support register into evidence? Trick question.
You can have the Attorney General, the attorney for that section of the office present at trial to authenticate that record, or you could have filed a business records affidavit prior.
Would it be, Jerry, do you think it would be prove-upable as a certified public document?
If it's certified, I think you can. They used to certify them, some offices would, and now they've gone away from that.
They've gone online.
Which is very frustrating.
Yeah.
I mean, there's the public record exception, which is if you are a entity of the state and you're required to maintain certain public records for mass consumption, and that is what you're offering, then you can try to get into that exception. I don't know, and I think that works.
Yeah. So you probably can get it in just as a public record then. What about calling the respondent to testify? Carrie, does self-incrimination apply?
The judge is going to admonish the respondent as to their Fifth Amendment rights not to testify. And if they don't, you should probably ask the judge to do so.
Yeah.
That's very important.
Yeah.
So let me ask you this, Judge. I mean, what if there was strategically by the petitioner just a pleading for civil contempt and not criminal contempt? Does self-incrimination apply?
On a civil contempt,
I mean, I don't know why anybody'd do that.
Civil contempt would be more like you want the respondent to sign an order, like Jerry's talking about, that he was ordered to execute a deed, and Jerry sues him and says, "I want him held in jail till he signs."
Yeah.
I don't think there's I don't know that the rights incident to criminal trial attached to those.
That would be my opinion, is that
and
self-incrimination
simply because
would not necessarily apply.
Yeah, simply because it's not the state. One of the things a lot of people don't realize on a contempt case is that the person receiving the child support or the person entitled to visitation is not the injured party in a contempt case.
Now, who is the injured party, Judge?
The court. So technically, if you file a contempt case and then say, "Gee, Judge, I decided to dismiss this contempt case," the judge can, I cannot imagine it happening, but the judge could conceivably say, no, you don't. You're going to prosecute this case.
Well, doesn't the authority for that come from the family code says that theoretically, I've never seen it happen, but theoretically a petitioner can say, hey, judge, he's violating the order, and the judge can appoint an independent counsel to investigate as a prosecutor.
That's correct. I've never seen it done either, but
Right.
you're absolutely correct. The court has the authority to do that.
Back in the day in Dallas County, there used to be the child support office. Do you remember that?
Guardian ad litem.
Guardian ad litem court, right? Wasn't that basically the authority for them
Yep.
doing it that way? Was it was an independent prosecutor? I mean, that was really before the OAG kind of took over that role. But
Yeah, that was the stated purpose of it, I believe.
yeah. So okay, so the respondent has to. Does the respondent have to present evidence in a contempt case?
No.
So the respondent can just stand on whether or not the petitioner proves their case.
Absolutely.
It's like a criminal case. And what Carrie's touching on earlier is if you're prosecuting a contempt case and you call the respondent, or the respondent has an attorney who maybe didn't go to law school and allows him to testify, be sure to ask the judge, say, Judge, would you please warn the respondent of his rights?
Yeah.
Because if you don't, and that respondent, the court's going to grant habeas corpus on that every time.
Well, so but as a judge, I mean, I've never been a judge and I've never been to judges school, but I'm told that in judges school they give y'all kind of a little cheat sheet manual of how to conduct a contempt case, right?
Yeah.
And it kind of has those warnings and things in it that you're supposed to give.
Well, it does, Michelle, but I will suggest to you that there's a lot of those scripts and cheat sheets and things like that judges are given in new judges school, yet you see some really odd things happen in courtrooms around the state.
Yeah. So what if the respondent has pled some affirmative defenses? Let's not say it's inability to pay, because I think he would have to testify in an inability to pay.
Right.
But can the respondent both refuse to testify but offer other evidence, offer witnesses or something?
No. I don't believe you can transactionally invoke in Texas.
Yeah. You can't pick and choose.
No,
invoking.
you can't.
Yeah. Well, what if it was a possession contempt case and respondent's mama was there? Could the respondent call his mama to testify and prove up his defense through his mama?
I think so.
Sure.
Yeah.
I don't see why not.
Okay.
And in fact, I think
Doesn't waive
that would
his
probably
rights.
be a good
Yeah.
tactical move on the respondent's part.
What if the petitioner attempts to call the respondent and the respondent invokes his fifth for the petitioner's case? Does that last all the way through the trial, or can the respondent then change his mind when it's his turn to present evidence and get up there and testify?
Kind of negates the purpose of waiving prior, because he's going to be subject to
Well,
cross.
right. I mean, maybe he's just waiting to see if they prove their case.
I think that's again transactional, and I
Yeah.
think that I've never seen that happen, but I think the net result of that, it's right off the top of my head, I would say he can, but if he later testifies, I believe the court can allow the prosecuting lawyer
To cross-examine.
Absolutely.
call
Yeah.
him back, recall him.
Reopen.
Uh-huh.
Reopen.
Yeah.
Yeah.
That would
yeah.
be fair.
Yeah.
Yeah, I mean, I would think as a judge, whether you can, it's one of those, the idiom, just because you can doesn't mean you should.
Exactly.
So, even if he can technically say, no, I'm not testifying in your case in chief, I'm waiting till it's my turn, I would think a judge would view that as kind of playing games.
Yeah.
And that might backfire on him.
Could.
Judges are the determiner of the credibility of witnesses, right, Judge?
Yes, that's true.
So that might backfire on him from that standpoint. So how would a respondent to contempt go through proving up, say, conditions precedent. Let's say it's a medical enforcement. And with medical enforcement, for the unreimbursed medical, there's some requirements for conditions precedent before the petitioner can recover. So what if the respondent was saying, those conditions haven't been met? How, from an evidentiary standpoint, could a respondent try that issue?
It's difficult to try because you're almost proving a negative in a lot of ways.
It's easier for the petitioner.
One, I think those provisions are unenforceable by contempt.
I agree.
Because you're talking about a percentage applied to an unknown number. Mm-hmm. How is that going to meet the specificity you need to meet Slavin in any case like that?
I agree with
So
Jerry.
I don't really think that burden is going to ever fall to the defendant. I think it's going to be the petitioner who's going to try and fail to get there.
I think it's absolutely correct. When you start talking about medical expenses, you're going to have to prove unknown providers,
Right.
unknown dates, and all this other stuff. And I think what your remedy on that is wait for the prosecution to put on their case and move for judgment on those counts.
Right.
Right. And then we talked about this a little bit in the last session, but what about a teenager? If a petitioner sues for contempt over a teenager who won't go on a visit, and a respondent is defending that, if I were a respondent defending that, I would plead impossibility of performance. But how would a trial like that, how would a petitioner prove up enough to prove contempt on a teenager possession, and how would a respondent avoid contempt on a teenager possession?
That's the one time we've talked about today where if I was a respondent, I'd be getting ahead with the evidence. Because if you just sit there and say nothing, then all the court's going to consider is, supposed to be on this time, didn't show up, and there you go. And what that respondent's going to do is put forth all the evidence and witnesses and recordings of all the times they tried to get their darling little child to go, and they said hell no, or actually left the house at the right time driving off and just never went to dad's, or even got to dad's, because you see this sometimes, and then immediately got in their car or walked home.
Yeah.
And all those, the only way the court's going to hear that is if you put on evidence.
Okay.
So,
Would you call the child?
if the child's 17, absolutely.
What if the child's 15?
Probably still yes. If it means I'm going to jail or not, yeah.
Well, and again, I asked this in the last session, but would discovery be available? Could you depose the child so that you don't have to put the child on the witness stand in the trial? Could you take a deposition?
I mean, if I'm the defendant, I think you got a lot better chance of getting the benefit of discovery than if you're the petitioner.
Yeah. I mean, I don't know what says you can't. It's kind of my point on that.
I don't know what says you can't put a child on the witness stand.
Well, I mean, I agree.
I mean, you can, yeah.
I agree with that. But I think from a practical standpoint, I've even tried criminal cases where we took depositions. I mean, I don't think that anything says you can't take a deposition just because it's a criminal contempt case.
Under the Code of Criminal Procedure, it's more difficult to take a deposition, obviously, but I think you're right. I think you can.
I mean, if you needed to preserve evidence for some reason, or like if there was some extenuating circumstance, like it's a kid, I don't want to call my teenage kid to testify in the case where somebody's trying to put me in jail, and you might do better with a deposition.
Now, I know 2 current Tarrant County courts that will not allow that. The child is going to take the stand, regardless of age. So.
Yeah, that was my policy. Is if you called a child, I just did the common law predicate. If the child was under age 7, they were presumed incompetent. Yeah. If they were 7 to 14, I had a hearing on their competence.
Yeah, whether they know right from wrong and that type of thing.
That's a very funny story on that. But
do you want to share?
They had a story I read in the Bar Journal years and years ago by Judge Buckmeyer, may he rest in peace. He was talking about a judge questioning a child witness as to her competence, and he asked her several questions, and he said, do you know how important it is to tell the truth? She said yes. And he said, do you know what will happen if you tell a lie? And she said, you will go to hell. And the judge said, is that all? And the child said, "Isn't that enough?"
That's great. So we got about a minute left. What are some practical tips, Judge, that you would give to litigants, particularly respondents, for avoiding jail time?
I don't really. I mean, these cases are so fact driven. When it's a non-payment of child support, the first thing I would say is try to avoid a trial. Get all the money you can together, and try to make peace with the petitioner beforehand. At least have something to offer. If it's a possession and access case, just do the best you can.
Yeah.
Hope for the best.
Yeah.
But
What about you, Jerry? Do you have any tips for trying a contempt case or defending a contempt case?
Well, one thing the judge pointed out earlier in an earlier session is the idea that if you've identified some error in what the petitioner has done, just sit on it.
Yeah.
yeah.
Just sit
So
on it.
that
and
was
move
an
for
interesting
judgment.
question. I actually had that written down for us to talk about. So from an ethical standpoint, do you think that it's ethical for a respondent's attorney to sit on error? You know, to wait until the first witness is called to say, hey, there's a defect in the pleading.
I do think it's in fact, I think
Absolutely.
it's required because you have a duty to your client of zealous representation, and I think that if you identify an error that is an acquittal type error,
Get out of jail free card.
exactly.
Yeah. Then you can't bring it up. Like if you bring it up and let the other side correct it,
Yeah.
that is unethical.
Right.
I believe that's correct.
Right.
Okay.
There's no requirement for special exceptions
Right.
in criminal work. There's just not.
Right. I think that's important because I think the standard is probably, well, I know it is different in like a normal divorce case. If you're going to complain about a pleading in a normal divorce case, the complaining party has an affirmative duty to file special exceptions and get a hearing and have it heard. But in a contempt case, it's the opposite. It's more it's like criminal law. You actually have an affirmative duty not to bring it up until you're in trial when double jeopardy attaches. Yeah. All right. Well, that wraps us up for this session. We are going to move on to drafting contempt orders after the hearing. So stay tuned. We'll be right back. Keep in mind that this is a webinar that's aimed at attorneys. This is for continuing legal education. If you're out there watching this webinar and you're not an attorney, we welcome you to watch it. But remember that we are not giving you any specific legal advice. We cannot comment on any specific case or situation without knowing all the facts. So if you need legal advice, this webinar is not a substitute for legal advice. Please seek the advice of a lawyer as to your specific situation and get specific advice to that. Because if you rely on just what we're talking about here, we're being general, we're talking about general legal principles that may not actually apply to your situation. This is for continuing legal education only, and we cannot create an attorney-client relationship just through the video camera. Okay? Thanks.
I'm going to put that at the beginning or the end?
Put it at the end of the introduction.
Okay, so like
Does that make
between
sense? Yeah.
between the intro and
Yeah.
part one?
Yeah.
You got it.